Now, the story we've been focusing on this morning, and particularly in our question of the day, the Judicial Service Commission has resolved to go ahead with its October sitting, despite the MK Party's threat of legal action. The party is seeking the postponement of the JSC sitting. This after the Western Cape High Court granted an urgent interdict of a three-part application brought by the DA Corruption Watch and Freedom Under Law to prevent MK Party parliamentary leader Dr John Hlophe from participating in the city. Now, attorneys on behalf of the MK Party contended that the effect of the interdict renders the JSC improperly constituted. Now, to talk more about what this means for Dr Hlophe's future in the Judicial Service Commission, we're joined by Nthabiseng Dubazana. She's the founder and director at Dubazana Attorneys. It's an absolute pleasure to have you, Nthabiseng. Thanks so much for your time.
Thank you so much for having me.
So let's get a bit of a legal understanding here. What does the Western Cape interim interdict mean for Mkhonto weSizwe's parliamentary leader, Dr John Hlophe's position in the Judicial Service Commission, as the application was in three parts?
Yes, so because it's an interdict, it is not a final situation wherein it is dictated that Dr Hlophe can no longer participate in anything relating to the JSC. So with the three parts that have now been, the first part having been dealt with, the remainder two parts, once they've been dealt with, then the applicants, which is the Democratic Alliance, I believe, and all of the other parties who are the applicants in this matter, have to now bring back the rule nisi, that's what it's called, have to bring back the rule nisi to the court to say that after the order that was granted on this particular day, Parts A and Part B have now been adhered to or have been dealt with, and therefore we are seeking that this interdict be made final, and therefore Dr Hlophe should not be allowed or permitted to participate in the JSC selection of judges.
I mean, for now, Dr Hlophe remains a member of the JSC until a further review of the National Assembly's decision to designate Hlophe as a member of the JSC is done, as requested by the court. My question is, what are the constitutional implications that actually could result from this?
So there is nothing in the Constitution that prevents somebody in the position that Dr Hlophe is in to be a member of the JSC. There's nothing in there that specifically says somebody who has been impeached or somebody who has a specific kind of thing attached to them in that kind of manner. Because remember, the application was that because he is impeached, he is therefore not a proper person, fit and proper person, I beg your pardon, to sit in the JSC and also adjudicate on the application and the confirmation of judges who are yet to be judges in the various high courts. So based on that alone, there is nothing in the Constitution or even in the law that prevents him to actually be part of the people that do that kind of work. So as it is, I believe what the MK is trying to do is say that in that respect, by virtue of the court granting this order, they are going against the Constitution, because nowhere in the Constitution does it condone what the Western Cape has currently done. We're not saying that the Western Cape is wrong or right. It's just saying that based on the application in the manner that in which it was brought to them, they are now granting this interim interdict on the condition that the review of the appointment of Dr Hlophe is done. And if the National Assembly is still of the opinion that he should continue in his role, then the Western Cape High Court may be forced to now remove the interim order and then confirm that he may proceed and conduct his duties.
Yeah, I mean, I suppose now we look and see what Dr Hlophe's next step is. And I imagine he will be able to appeal this interim interdict, but will this be able to prevent the next JSC meeting this month?
We hope not. Unfortunately, we are struggling severely in the high courts. We have a lack of judges. Matters are delayed. I mean, we have dates for opposed matters coming 4.5 years, 5 years from now, that's the only date you can get. There are no dates this year, next year, or the year after. So that in itself, if this delay is done, we are finding ourselves in a dire situation. So we don't know. We hope that it doesn't delay the process and then it actually starts, so that maybe we have some glimmer of hope that we'll get dates sooner than 4.5 years from now. But in the manner in which things are going, I do have a feeling that it may be disrupted with the legal application that will be brought by the MK party to stop or halt the process whilst their legal battle in terms of the interim order that has been granted to be uplifted so that their member can be allowed to participate in the proceedings.
I must say it's important to actually get the perspective of what's going on in the courts and how important this actually is, even though there's wrangling on the sides in terms of what's happening on the JSC. But it's the functionality of the courts that has come under the spotlight as well. And, you know, this needs to move on. We cannot afford to have any more delays. And I'm glad you've brought that up. But let me ask you this. I mean, was the DA and the NGO's urgent interdict about the independence of the judiciary, is this what it's about? Or is it actually just a political matter that's at play here?
You know what, I'm not sure if I would say if it is a situation where we're doing a balance and checks situation, because remember, when we move from the apartheid system to the system that we have now, the executive, the legislature, and parliament have to check on each other to ensure that one doesn't work independently of the other, and therefore the executive doesn't make decisions on its own, which is going to affect the country in a negative manner. With that being said, we've seen so many matters relating to political issues being resolved in the courts, whereas there are other forums that could be used to resolve these matters. So this also adds to the judiciary not having enough adjudicators or judges to deal with these matters. So unfortunately, our courts seem to be a political playground, because that's where most of our political parties go to try and resolve their issues, instead of maybe going for an ADR situation or going to the respective forums that can deal with it. They go straight to the courts. And now the courts have to deal with the political issues, because if they don't, they affect the country adversely in whatever situation that is happening there. So I'm not sure what exactly is happening here, but what I do know is that it is extremely frustrating on the court system, because matters in all aspects, it used to be just Gauteng, but it's now spreading throughout the country, whereby most of our high courts cannot handle the load. And when we appoint acting judges, they're only appointed for a period of 2 weeks or 2 months, and that's not enough. And when we request, or when there's a request that people should apply for a longer term for acting, there's a requirement whereby you have to have 15 years experience and all of those things. And a lot of the people who have 15 plus years experience have retired, or they're no longer interested in doing what, adjudication or judging or whatever the case may be. And then the rest of the parties who are 10 years experience, who are actively in litigation, are prevented from actually assisting the High Court. So we are dealing with a situation where we're stuck between a rock and a hard place. Yeah. So it's a mess. That's all I know. It's a mess.
That's not great news to hear that as well. Just let me quickly just end off with this. The MK party attorneys have contended that the effect of the interdict renders the JSC sitting improperly constituted. That's what they've said. Do they have a case?
Yes, so they are, the requirements are that the JSC has to have certain members from different political parties, right? And each party has the privilege of appointing whomever that they want to represent them in the JSC. So now, having been denied the opportunity for their chosen member to sit in there, they are saying that it is improperly constituted because it falls short of the requirements in terms of section 178, if I'm not mistaken, of the Constitution. So therefore, if they're going to challenge this order as it stands, they'll be challenging it based, I believe, on that particular aspect, that it is improperly constituted, there's somebody who is missing. There's a shortage of people in terms of how it's supposed to be sitting, and therefore it should not be sitting. So the argument that the DA had raised in their papers is saying we're not preventing the MK from having a member in the JSC. We are only saying that they must remove this particular person and put somebody else. So they're saying that they are being dictated to as to how they're supposed to run their party, and they're saying they're refusing to do that. So that is where the impasse really is, and we will see how the court action is going to deal with it going forward.
All right, let's leave it there. Thank you so very, very much for joining us here on the program. And Nthabiseng Dubazana, founder and director at Dubazana Attorneys. I know, rushing off to court right now. And thanks so much for your very special time. I mean, the functions of the JSC basically are, if you don't know, to interview candidates for judicial spots, make recommendations for the appointment to the bench, and to deal with complaints brought against judges. And as you heard, this is now delaying a lot of this, and they do hope, I suppose, judges and those in the legal fraternity hope that this doesn't delay any further. But it's an interesting one that we'll keep an eye on.